Morning.
Good morning, Judge.
Good morning, Judge.
Good morning, Judge.
It's good to see you all.
Nice to see you as well, Judge.
Same
Are we
here.
ready? Are we ready to start?
Yes, Judge.
Paul, please call up the matter. Paul, are you there?
Acting for respondents, right?
Yeah. Okay. In the Special Tribunal of South Africa under case number GP 17/2020, in the matter between Caledon River Properties Pty Limited and Prof Team CC against the Special Investigating Unit and the National Department of Public Works and Infrastructure. This is an application for leave to appeal. Council may place themselves on record.
May it please the court, my lady,
Just
GJ.
want to make sure, sorry, Mr. Skippers, the recording is not on.
Yeah, Judge, only the convener can put it on. I can't
Yes,
put
I
it on
know.
from my side.
I know, yeah, she sent me a message. She's battling with the network.
Judge, then we should just stand down and wait for her and see whether she will come on.
We need to have it recorded.
Yes. She let us all in, so she's the host, she should be here. Ndipeleke? Are you the host? Mpo is the host, okay. Okay, thanks. I believe that some of you are going to court at 10. Does anyone have time constraints?
I don't, Judge.
You don't?
My lady, I only have a constraint at 2 o'clock.
At 2 o'clock, okay.
I'm also without any restraint, my lady.
Doesn't mean we're arguing, we're here the whole day though. Why did we start this early then? I was meant to be.
My lady, I'm involved in a trial in Durban, but the matter subsequently collapsed, as happened with all trials of long duration. So we would have proceeded for 4 weeks every morning in
I
Durban.
see. So that was to accommodate you, okay?
And we indicated that that's not the persisting problem anymore, but the date state and time state as it was.
Okay, that's fine. Okay, I'm gonna switch off my video to try and get hold of Mpho.
Thank you, Judge.
I'm standing down.
As the court pleases.
First applicant for leave to appeal side, my lady.
Neither from me.
Neither from us, my lady.
Let's proceed. Mr. C, perhaps I should just ask you whether at any point, I remember being asked whether the application for leave to appeal should be filed with the tribunal or whether you should proceed straight to the full court. One of your, the applicant's attorneys would have asked that question. And what I indicated to my clerk, Mpho, is that you will recall, counsel, that in Caledon 1, there's a remark I made on the basis of the provision in the Act, in the SIU Act, that the special tribunal does not have express powers to grant leave to appeal. The Act simply says that an appeal against a judgment of the tribunal lies with the full court. It doesn't say on leave being granted. So that question for me remains. And I have noted an inconsistent approach by parties who pursue appellate proceedings. There are instances where, in fact, this is the first application for leave to appeal, no, the second. By me, it's the first. I know Judge Motle had one, and I just recall that Judge Siwendu also had one. But we have matters where parties simply proceed to the full court without seeking leave. So it appears to me that that issue needs to be resolved, finally. And it's one that cannot be resolved by me sitting as a single judge because there are conflicting approaches. However, this issue has not been fully ventilated. It wasn't argued before Judge Motle. It wasn't argued before Judge Siwendu. It wasn't argued before me in Caledon 1. It's a remark I simply made because at that point I was analyzing, whether this court is a court with a status of a high court or whether it's not a court, as was argued there. So it appears to me that this issue has to be argued. And I did ask Mpho when that question was asked, that I did indicate to her that this issue is a pending issue. And if you believe that you ought to come to the tribunal for the application for leave to appeal, then you need to argue the point. And I see that this issue is not addressed in your heads of argument at all. So the starting point is whether this was communicated to your respective attorneys.
My lady, from our side, we know there was an issue about whether it should have been filed, whether it was at the High Court or at this court, but we weren't told that we need to address the issue. Yeah, we weren't told to argue the issue, my lady, from our side, from Caledon's side.
Mr. Tron?
My lady, I saw somebody sent me, probably my attorney, a practice directive for 2 other matters to be heard before a full bench to argue this point. When I say full bench, more than one judge in the tribunal.
Yes.
The Act says what it says, and it doesn't require leave. Your finding that the tribunal is a court creates an anomaly in the sense that an appeal now suddenly lies without the court granting leave, which is what is required of every other court.
Yes.
But the Superior Courts Act is silent on this, and the Superior Courts Act's definition of a court doesn't include the tribunal.
No, except, can I just assist you there? The Superior Courts Act is actually not silent on this, right? And this is I've since changed my view. In fact, my view was not that the tribunal does not have powers to hear an application for leave to appeal. I simply observed that the Act does not expressly say so. So there's a provision in the Superior Courts Act. I can make it available at the later stage. I didn't note it. We are now being recorded. There's a provision in the Superior Courts Act to the effect that an appeal against a decision of a court with a status similar to the High Court either lies to that court or to the Supreme Court of Appeal.
Yes, that may be so, but it doesn't say whether leave is necessary.
No, it does. It does. It says no. It says an application for leave to appeal against a decision. It either lies in this court or in the Supreme Court of Appeal.
Lady, this is an important point for other litigants as well.
It is.
I wouldn't want to argue it off the cuff, and it may be a situation where this application should either be postponed to be heard after the full bench has decided, or that we come back to you and argue the point properly with heads.
Yes, this issue is not pending anywhere at this point. Okay, it's not before any full bench. That full bench was not that I had requested, was not constituted because there were not enough judges in the tribunal at the time to constitute it. But the parties are since not persisting with it. They have gone.
Sorry, Judge, we can't hear you. Judge, can you hear us now?
What do you say?
Judge, we can see you again.
Yes, that was my network. Sorry about that. Okay. Yes, I was saying the issue is not before any court at this point because those directives are no longer of any effect because the applicants in those matters decided to abandon the application that they had lodged here and they went straight to the full court. However,
Yes.
there is another application pending in the tribunal for leave to appeal.
If that's in digital vibes, I mean,
Divided.
is that in digital vibes, my lady?
In digital vibes, yes, it's pending here. That
Yes, that's me.
application is pending.
That's me.
Pardon?
That's me.
Is it you? You were not there. You were not there in the
Mr.
proceedings of
Parment,
first instance.
Mr. Parment has suffered a groin injury, and I'm his replacement.
Oh, I see. I see. So,
My lady.
okay, my suggestion is this is an issue that needs to be argued so that I can consider it. I've not considered it. Yeah, I don't think we should entirely wait for the full court because, yeah, the application will will remain pending for quite a long time. So my suggestion is that you continue to argue this application so that we don't waste today. You have prepared, and then you can make written submissions on the question. It's a very succinct question. It's a question really, in my view, about, interpreting the provisions in the Act and, applying your mind to the question whether the Superior Courts Act is applicable in this instance, whether reliance can be placed on that provision in the Superior Courts Act.
Right.
But it's one that needs to be finally considered, and I think it should, if it's considered by the tribunal, it will give other courts, in the event that that point is taken on appeal, it will provide an opportunity for the issues to be further refined if it's considered by the tribunal.
Yes. Happy with that, my lady.
Happy with that, my lady.
We are happy. We are happy, my lady.
Okay, and if we do take an adjournment, I'll look at the provisions in the Superior Courts Act and give it to you, because I think that would be of assistance. Yes. Okay.
My lady, should we then proceed with the application for leave on the merits?
Yes, let's do that. I'd like to give direction on your presentation, on your oral argument. Your grounds of appeal are elaborately set out, and your written submissions are very comprehensive, for which I am grateful. It is pertinently clear from the judgment that I did not consider the evidence that was filed by way of affidavit. And that is what prompted fundamentally this application. Now, the question which Mr. Semenya clearly addresses in his written submissions, which unfortunately both you, Mr. Skeppers and Mr. Tron, don't address in your written submissions, is the test in this application. Right. So the issue is not about what you state in your written submissions, what I should have decided, because this is not a re-argument of the matter. The issue is about, if I grant you leave to appeal in the event that I eventually make that finding that I do have such powers. Sorry. What will the Court of Appeal find? That really is the question. So the question is, there's evidence I did not take into account, and that's a regrettable error. It's very humbling when such things happen and a judge gets reminded that after all, she is human. But that's why there are appellate provisions, because the legislature does recognize that such errors could happen. The Court of Appeal, in the event that you eventually get there, will have that evidence before it. So the question that we should be engaging on today, as I said, is not what I should have found. It is what that court, bearing in mind the evidence that I did not consider, will find.
We'll stick to that, my lady. I'm very glad, because I think I and Mr. Tron and myself were extremely worried that we failed to place evidence before you, and we were considering, but we did recall that we did confirm that we were able to tender it orally as well.
I don't want to go into detail about what actually prompted this error, because I take full responsibility.
No, it's no problem, my lady. There's an elephant in the room.
Yes, I take full responsibility for it. That evidence was filed. I think what I did not have regard to, because it didn't appear on case lines at that point, is the minutes of your pre-trial conference. Yeah, that's what I didn't have. But that evidence was found. Yeah,
my lady, I will then restrict the argument on behalf of Caledon to the and do not at all deal with what was not considered. And the simple issue, and that has been ventilated in the heads of argument, is that the evidence was uncontested on a factual basis.
yes,
That there was no malfeasance on the side of the contractor and the engineer. Similarly, there was no issue raised on the evidence before your ladyship pertaining to the work that was done according to specifications and in line with what the approved amount was, and that the completeness of the performance was undisputed before the court. Now, that is the evidence then that a court of appeal will have before them, and it will have no evidence to refute that. And the issue that then will have to be decided, if one considers what was said in Gajima, Buffalo City, Aslam, as well as the latest SCA judgment of the attorney's firm, is whether your ladyship, in excluding or not entitling the contractors and the engineer from profit, in fact, made or exercised a misdirection which would authorize the Court of Appeal to interfere. And I immediately have to concede that it is a value judgment that has to be exercised in deciding on the remedy. But I would submit respectfully to your ladyship that if one considers the undisputed evidence, including the evidence of the experts, that there is a clear pattern here of no blame to be apportioned on the contractors. And the one example that I wish to raise with your ladyship, if one considers the objective fact of a emergency situation, definite involvement from Parliament and the executive side, and the failure to record the deviations that took place into account, an exclusion of the entitlement to profit will effectively be a red flag for any party contracting with the state, for the simple reason that you would effectively have to perform a due diligence on every tender to make sure that the state is in fact complying with its obligations, because it is a tender, in most instances, evaluation and adjudication system that takes place. The compliance issues is addressed by internal systems within the departments, with no provision for participation in that process by a bidder. I cannot, on behalf of Caledon, say to them, guys, we are worried that you might be flouting the Treasury regulations. I would like to see exactly that you are complying with each and every instance. There's no provision for oversight or even insight during that process for a bidder in a evaluation or adjudication process. Even if that exists in the timelines, which is also not in dispute, this was an issue of national importance, and that has never been disputed. So for Caledon to have said, well, sorry, guys, you've told us that the minister works at the instruction of the president, that the Minister of Defense, everyone is involved in this. We have 1 month to finish this. To double guess that in these circumstances, where national interest is at stake.
I'm here. Mr. Tron?
I can hear you, but Mr. Skeppers is
Oh,
frozen.
sorry, Mr. Skeppers. I meant to say him. He's moved. I can see him moving from my side.
On my side, he's not moving at all.
Okay. Okay, it's disappeared now.
He's trying to redial in, my lady.
Okay.
I'm sorry, my lady. It seemed that that here at the Tswana Society of Advocates, we have been robbed of our connection for a short while. I'm back on my phone.
Okay, welcome back.
Thank you, my lady. I apologize for that. So my lady, I was last at the point where what the applicants for leave to appeal were confronted with. And that is the true issue where we submit that another court would come to another finding in as far as the availability of a remedy for the applicants for leave to appeal lies in as far as the performance were concerned. Because your ladyship found that there was no malfeasance on their part, but that as a result of the interpretation of all pay and the principles set out therein, as well as Vision Works and those cases, that one cannot benefit from an unlawful contract in the sense of profit. But we humbly submit that that issue, according to what the Supreme Court of Appeal and the Constitutional Court has said, is not as trite as that finding, with respect, my lady. In all the cases that we have referred to comprehensively in the heads of argument, the remedy was made available in circumstances of non-compliance and where profit was not excluded as part of the remedy that was granted. And that will be the true issue based on the undisputed facts and evidence that another court would consider, and where we submit leads to the probability that a court would come to another finding, and not only could come to another finding, as was the historical position. And we submit that is the real issue. There were lots of side issues that featured as well, but that is the true issue that will have to be decided, whether profit should be excluded, having regard to the specific circumstances of this case, and the undisputed evidence that the value did not exceed what the cost ought to have been, that a process were followed in order to start at a base, and that the work were completed under budget within time in accordance with the specifications as supplied. The real issue is if the department made terrible mistakes as to how they wanted the fence built and their design, that could never exclude a bona fide party participating from discharging the state from its obligation to perform in terms of its contractual obligations, even if it did not strictly comply with the process.
Yeah, and I gather from the tone of both your applications for leave to appeal as well as your heads of argument, that's where the main issue that grieves your clients. You know, the fact that they have performed to specifications, and one is not oblivious to the lot of public noise about the deficiency of the product that was delivered, you know, and the apparent loss to the state because the product, a very expensive product, is deficient. In my judgment, I lay no blame to that on your clients. I did not. It's actually a very neutral judgment. You know, I lay no blame to that on your client. And I think you correctly observe that ultimately this issue continues, even on appeal. It will turn on the interpretation of the dictum in all pay. Ultimately, it will turn on that. Mr. Skeppers, I'm not persuaded that in a court of appeal, considering the factors that you rely on, right? Because you correctly point out, it's a value judgment. You've enumerated the factors you rely on. And you are saying because of those factors, your client should not be deprived. Some of the factors you rely on, for example, the absence of malfeasance, innocence, performance to specifications. Those factors were present in all pay.
Yes, my lady, but subsequent to all, sorry.
Wait, let me,
sorry, my lady.
You can respond once I have put this to you. Most of these factors were present in all pay. The issue around the fact that there was no deviation, that speaks to that's an irregularity issue. It was settled between the parties, right? Now, the whole purpose of a just and equitable remedy is to correct the offense to the Constitution. Is that not so?
That is indeed.
Yes, the authorities are very clear about that. The purpose of just and equitable remedy is to correct the offense to the Constitution. Because the law is very clear. If an organ of state acts contrary to the law, their conduct is unlawful. The law is very clear on that. So given the affront to the Constitution, which has been conceded, which is common cause, the question now becomes, what was the affront to the Constitution and how is it corrected? And again here, no blame on your clients. Let's look at section 217, which is the section that has been offended, right? It requires that procurement is undertaken in accordance with the values of fairness, equity, transparency, competitiveness, and effectiveness. Now, where there's an irregularity, there is an affront to these values. I will focus for the moment on the issue of unfairness, transparency, competitiveness, and cost effectiveness. Right. Just when we consider the question of unfairness, transparency, and equity, the procurement prescripts are designed to ensure that when a tender is awarded, it is awarded in a manner that is fair to every potential bidder who would have bid. That it is awarded in a manner that is equitable to every potential bidder who would have bid, and that it's awarded, he's gone again. Welcome back.
Sorry, my lady, I don't know what's going on. My attorney also lost at the same time on both devices that we have. I was lost with your ladyship on all the factors that were being considered, transparency, competitiveness, all of the set out in section 217.
Yeah, so just to make this point, I'm going to focus on unfairness and transparency, right?
Sure.
So,
I'm here, my lady.
yes, the procedures, the purpose of the procurement procedures is to ensure that every potential bidder has a fair opportunity to bid. And the bidding process is transparent, you know, to ensure that the process is fair, right? So where the prescripts are not complied with, there's an affront to that value. So when a tender is awarded under those circumstances, it becomes difficult to correct because we actually don't know whether, if the prescripts were awarded, this tenderer would have been the successful bidder. We don't know that. It could well be that if all these principles were observed, Caledon River Properties would not have been awarded this tender.
Well, my lady, but
wait,
yeah, I'm sorry, I'm listening.
Yes, because remember, it was awarded a tender under circumstances that were irregular. So if the tender was awarded regularly, we do not know whether it would have been the successful bidder, because the process was supposed to be fair to every potential bidder. It was supposed to be equitable to every potential bidder. It was supposed to be cost effective. It was supposed to be competitive. We don't know how much other bidders would have bid. We don't know. The importance of that, Mr. Skippers, is that we actually don't know whether Caledon River would have gotten this bid. And that's where I have a difficulty with the entitlement argument. We don't know whether it would have gotten this bid, right? And how do we then correct? How do we then correct this offense? Because we're now dealing with a party who has been given a government contract under circumstances where it's actually possible that it would not have gotten the contract. And that's where All Pay is of assistance. All Pay says, under these circumstances, nobody loses, nobody profits. That's how we correct the affront to the Constitution. Nobody loses, nobody wins. Right. Now, your argument is that, but no, wait. The Constitutional Court, the SCA, has, under certain circumstances, allowed bidders to bid where a tender was set aside due to irregularities. Indeed so. But you correctly point out it is a value judgment. The Constitutional Court or the Supreme Court of Appeal didn't just allow these bidders to retain their profits. There are factors it considered. Right? And if you look at those factors that were considered in Government Beggy, in Buffalo City, I am not persuaded that on the factors you rely, your client will be entitled to retain its profit. Because if you look at my order, that order fully compensates your client. Even it relies on for example, the emergency factor, the fact that it had to hire security, accommodation, all those extra expenses to deliver the service, it stands to be compensated for those costs. So that this order, if this order fully corrects the affront to the Constitution. Now let's look at what happened in Gijima, for instance. In Gijima, a tender that was Gijima was put in a position, was urged rather, to relinquish a tender that was regularly awarded for a tender that was irregularly awarded. So Gijima was really prejudiced. It lost because if it did not relinquish the first tender, it would have derived profits fully from the first tender. Right. So it was urged to relinquish that in exchange for another tender, which was irregularly awarded. So the second tender was set aside and it was allowed to keep profits, to compensate it for the loss that it incurred under circumstances where it was entitled to profit from the first tender. You see, that was clearly to compensate Gijima. So here the order fully compensates your clients to what he is rightfully entitled to. But to profit under any regular tender, I'm not persuaded that your client is.
I hear what your ladyship say, but just let look at the circumstances of this case. For 30 days, my client could not do any other work. So for 30 days, he's entitled to no profit, but only his expenses. That, my lady, would be equal to taking away 8.2% of his income earning ability for a year, because companies live from profit, not from expenses, because there's no provision for any markup in your order. In addition to that, my lady, your order seeks us to revisit issues that was undisputed before your ladyship on what the actual costs were incurred. That was broken down in detail by the expert as well as each of the witnesses on what the costing were. Your order, in effect, would give Mr. Semenya's clients a second bite at the cherry to now come and gainsay something that they elected not to oppose in the main application. So if one considers it from that background, what we have is, we have no evidence that anyone else could have done the work. We have no evidence from the SIU or Department of Public Works side to say the work would have been done for less by any other potential bidder. So what the order in effect entails, my ladyship, is that your ladyship takes the potential that they might have paid too much. Because let's accept for a moment another tenderer in terms where the deviations were correctly recorded, built exactly the same fence for 1 million rand less. It would still be a terrible fence, which was the biggest gripe that everyone had with this fence, because they said it does not serve the purpose. It would still have been a fence that wouldn't have served the purpose built by any other bidder. There's no evidence, to your ladyship, that any other bidder would have been able to do it for less. And that takes away any probability that there is a detriment for the state in when they got the bargain that they wanted. Whether it was delivered by Caledon, by any other contractor, it would have been the same fence. Whether it would have been in 30 days be another matter. But what your ladyship's order entails is that I would do a trial for a month, and if my chamber fees are 100,000 rands a month, I can have my 100,000 rands a month and my secretary's account. But for that month, because the state attorney did not properly follow the process in appointing me, I would not be entitled to my normal day fee, because that would be profit.
But
and
remember, we don't know whether, had processes been followed, you would have gotten this tender. It could well be that you may not have gotten it. It could well be that you may not have gotten any business in that month. So for lending for profits under circumstances where it's possible you may not have gotten the business in the first place, doesn't sound correct.
My lady, my dad always said to me, everything is possible, but everything is not probable. And that is with respect, the mistake or misdirection that I submit the court made, and in your argument is still evident. There is no evidence before your ladyship that another tender, that any change would have impacted on a lesser amount. That bird has flown. The state did not dispute that the value was there, that they did not overpay. There is no attempt to deduct 10% or 5%. It's a win or lose attitude by the department. They said first they want all the money back. Then they said, well, you can keep your expenses.
I wasn't with them on that. Clearly, they've lost on that point. In fact, they didn't persist with it because they, I think it was quite prudent of them not to persist with it because it was not in accordance with the law.
No, I'm with you, my lady, but once again, no evidence was led to even show a probability, because what does the court work with in a value judgment? On probabilities and not on possibilities, because anything could be possible. But on the probabilities, in the absence of evidence that another tenderer would have done the work for less, your ladyship might have been confronted with a proper system setting out that one of the other tenderers who were invited would have done it for 1.2 million rand less or 1.3 million rand less. That's not before your ladyship, because on your ladyship's argument, profit might have been payable if another party was there, but if the fence were bad, it would still have been fair to pay them because they had a chance to. There's no evidence that anyone else could have done the work in the time frame for the price that it was done. That's not before your ladyship. To speculate that someone else might have done it now excludes the contractors and the engineer from their earning capacity, because there might be a possibility that the state might have saved money. What we need to keep in mind, my lady, is the fact that
I didn't say the state could have saved money. What I said is that all potential bidders have the right to bid for a tender. Right? Now, if a tender is awarded under circumstances where potential bidders are excluded, you can never say that if the process was fair, your client would have gotten the tender.
My lady, I respectfully disagree with the court with the greatest of respect. What your ladyship, if I may engage in the argument on that matter, what your ladyship says is, if a process was not followed, then no one is entitled to money, but the state would get the bargain. So let's for a moment take that a perfect fence was built. The Minister of Defence patrolled every day. There was a fence that on any scenario would be worth 45 million rands. But because other people did not tender because there was a state of emergency and the department made a mistake in recording the deviations correctly, now the state should get the benefit from that wonderful fence that's standing there, keeping the smugglers out for 30 million, because that would be the cost of the operation, but there would be no problem.
Unfortunately, that's not the case here. And that's been found in other cases, that has happened in other cases where the product or the service was good, but profits were still not kept.
Well, my lady, the attorney in the matter, I think it's Sekaku, he kept his profits. He could keep all the fees for the work that he was done. In Buffalo City, Oslo, the contractor kept all the houses that he already built, irrespective of the irregular awarding of the contract. Those are instances which is exactly
Remember,
opposite.
in Buffalo City, the issue was delay. That issue is not present here.
Well, my lady, there was no chance for delay because it was an emergency project, and that's the problem with it. Right?
Exactly. And that point, actually, depending on how you look at it, it could work for you, but it also does not work for you, because if you look at the number of procurement contracts that were granted in that emergency, it just it renders Buffalo City distinguishable, because in most of those contracts, like it was the case here, it was an emergency. By the time the government became aware of the irregularities, performance had already happened. So it does not follow that because it was an emergency, then your client is entitled to profits.
But let's look at what happened in the emergency. Mr. Tron addressed it in argument before your ladyship in here. The state got what they wanted, within the time they wanted, for the price they wanted. And if you consider the objective facts, the invoice was even less than the tendered amount. So here the 30 days. 30 days in extreme situation, a fence was built exactly according to the specifications. Now down the line, and let's look at where all of this started, my lady. It started because they said it was a badly built fence. That was the whole premise upon which it was done. And we now know that was totally untrue. The fence was not badly built. It was built precisely in accordance with the specifications, within the time, and under budget. So there's no prejudice for the state. What the mistake is, the fence that the Minister of Public Works wanted is what Mr. Veldsmann said, a 2-year project and 245 million rands. And that is where the complaint came from. The complaint did not come from the fact that it was overly expensive. It says it's too expensive for what we got. And that makes it distinguishable from all pay in all respects, my lady. But I mean, the argument is the argument, but your ladyship just in argument said, well, it might work for you, it might work against you. That at least leaves the possibility that another court would come to a different finding than your ladyship based on those circumstances.
No, but remember what I said, Mr. Tron. I said it works for you because you stand to be compensated for all those expenses that you incurred. Having delivered having performed in an emergency, that's where it works for you because you are compensated for all those expenses.
But we lose 1/12 of a year's potential income for a company, which is the lifeblood of a company, because companies don't work at cost. On the mistakes made by the department and their failure to act, this honourable court in the judgment takes away 9% of the income earning possibility of the company as a result of the mistake of the state, which is uncontested. So looking at what happens here, the message is that if you do work with government, and it's any form of emergency, unless you can make 100% sure that government has done their part, you should not do business with the state. Because if your ladyship, if this is the context in which it has to be evaluated, if I have a client that said to me they have an urgent tender that they have to comply with, I would have to say on the basis of Caledon River and how all pay has been interpreted, you should not do business with the state, because if they make a mistake in the procurement process, you will only get your cost. If it's a 3-month contract on this one, you lose 25% of your income earning potential for a year. And I submit your lady that your ladyships in that argument loses sight of what's the lifeblood of business. The lifeblood of business is profit. Profit is not net profit. It's the gross profit generated through a year in order to declare a return for the shareholders. That's how business operates. And on this instance, as a result of what we all now know was the state's mistakes, the shareholders who places themselves on a limb in order to conduct business will lose the possibility of any dividend for 10% of a year's work. That is the essence. And I mean, some people might think it is funny, but it's in fact a very serious issue having regard to the economic hardships that companies are facing. And that's the reality why I submit that another court would come to a different finding than your ladyship on that issue. That to disentitle profit basically takes away 10% of what the company can earn in a year. You don't make up 10% in the current economic climate, my lady. 10% will be carried for time to come and might eventually lead to the downfall of several companies. So those are the submissions. I understand your ladyship's argument, but I unfortunately cannot make a single concession on your ladyship's argument. And the issue remains, as we have pointed out in our heads of argument. Your ladyship either is going to agree that another court, in line with what was recently decided, would come to a different finding. It is an issue of paramount importance for people doing business with the state that this issue be resolved on whether where emergency contracts such as this is done in line with the specifications because of a deviation in failing to correctly record during the process, whether that should disentitle profit. And that's the long and the short of the argument. And I submit to your ladyship that there's sufficient factors to argue that the SCA and or the Constitutional Court may very well agree with the applicants for leave to appeals argument on why they should not be disentitled from profit. My lady, then the remainders of the orders provide literally that everything that was undisputed in the trial have to be reproved at great cost by the...
Let me just debate with you on how I saw that, why I allowed the respondents to file an expert report. You will recall, Mr. Skeepers, when the postponement application was argued, that you actually said to me that the quantum issues will have to be decided at a later stage because those issues are not fully ventilated. We can obtain the recording. You specifically made that point that it's up to me whether I grant the postponement or not because the quantum issues are not fully ventilated. And what was actually considered, what was fully argued and considered at that point was the merits aspect of just and equitable relief and not the quantum issues. You made that point during all.
Then I made a mistake, as your ladyship did, and then I apologize for that. That is the issues. I listened to the recording. We tried to obtain it in the meantime as well. But I mean, the main issue remains what we have argued. And I think
that recording should be transcribed. That recording should probably be transcribed. It will assist in the event that, you know, I grant leave, you go forward. It might assist that court in considering what was actually before me, in understanding how I approach the matter, given what was before me. What was before me was purely a legal question of whether, under those circumstances, just and equitable relief should be granted. It was not the quantum.
Lady, I abide by what your ladyship decides in that regard. The issue is those are all issues that can be properly vented once the record are typed, which will form part of a record for a court of appeal, and the issues can be properly assessed. But the issue that remains paramount is that there is a clear difference in approaches and argument, not only by this court, but by the Constitutional Court, where it differentiates depending on the circumstances. And we submit that the circumstances of this case warrants a differentiation from all pay in line with what was done in the others as a result of the factors that we have indicated to your lordship. If your ladyship is with us, I submit that the leave to appeal ought to be granted. If your ladyship is against us, I mean, that leaves the remainder of issues open. I can't take it further than that. If your ladyship don't agree that another court would come to another finding, then your ladyship will dismiss the application.
Yeah, in the event that I'm with you that leave to appeal ought to be granted, to which court, Mr. Skeepers?
Well, my lady, that's part of the other question. The Act says that you shall appeal to a full court of the division. Yes. But if it's a leave to appeal, then your ladyship has to decide whether the issues of national importance and grant leave to the SCA in this instance. That would be my submission, but we can deal with that issue in the supplementaries. But I would submit that having regard to the great publicity of this case, that it is in fact an issue where the Supreme Court of Appeal has to deal with this, because we will delay the inevitable, because all the parties will eventually want to come to the apex in order to have a finding on this issue. And I would submit that having regard to the latest judgment of the SCA, which was as recent as December, that this is a case that would fall within the ambit of what the Supreme Court of Appeal would consider. And if your ladyship is then a party granting leave to appeal and not with the right of appeal to a specific court, that your ladyship would have the discretion to grant it to the court for which your ladyship believes complies with the requirements of the SCA to adjudicate that point.
Okay. In your written submissions on whether this court has powers to grant leave to appeal, please, set out a considered argument on that point.
I will do so, my lady.
Thank you.
Thank you, my lady.
Thank you, Mr. Tron.
Yes, my lady. My lady.
The issues between the two of you are largely the same. Can I request that you do not rehash what we've dealt with?
No, I agree with Mr. Skeepers' submissions. In the main, there's a couple that I differ with that I'll tell you where I differ. I want to start with the Supreme Court of Appeal judgment in Khomo, Dubai Municipality. I've uploaded that to case lines in a section so your ladyship can find it there. In that case, the attorney's firm submitted a non-responsive bid. if one translates that to your ladyship's argument, it's clear that another tenderer would have gotten the tender had that mistake not been made. As a matter of fact, because there were various tenderers, their tender was unresponsive, they shouldn't have got it. So very similar to this case, in the sense that even if your ladyship accepts that there may be another tenderer that would have got it and that our clients would not necessarily have got the tender, the Supreme Court of Appeal says this in paragraph 15 of the judgment. It is appropriate, however, that where no fault lies at the door of Sekoko attorneys and that rendered services would redound to the benefit of the municipality, an order is granted for payment. In those circumstances, it's just and equitable to order that the municipality pay to Sekoko attorneys an amount equivalent to that which it would have been entitled under the void tender. There's nothing to distinguish the Fetakomo judgment from the facts in this matter. Not a single thing.
Mr. Tron, in all pay.
This is after all pay.
In all pay in Gijima, the Constitutional Court made it very clear that the innocence of a tenderer does not entitle it to profits.
No, my lady, but on the
so
facts.
Maybe actually this is an issue for the Concord to finally resolve and not for the SCA.
Yes, my lady, I'm saying that a higher court than this court has made a finding on facts that can't be distinguished and allowed invoices that had been rendered but not paid to be paid in full.
Yes, and but a higher court than that court.
Well, I said to your lady,
has not granted profits.
Yes, and your lady,
perhaps, this matter should go that far.
My lady, this matter can only go that far if your ladyship grants us leave. And I'm saying that court in Fetakomo, the court in Fetakomo, with these facts, would have given us our profit. There's nothing to distinguish that matter, and it's a recent SCA case. And there are competing judgments. So on the second leg of the section, your ladyship should grant leave because there are competing judgments of the Constitutional Court and the Supreme Court of Appeal.
But Mr. Tron, that cannot. I mean, are you saying that do you know how many cases I preside over where these issues are debated? So are you saying because there are conflicting judgments, all those cases should be appealed right up to the Concord? No,
I'm saying to your ladyship that section 17, 1 and Roman numeral 2 says, if there's some other compelling reason why the appeal should be heard, including conflicting judgments on the matter under consideration, that's a ground for granting leave to appeal.
Let's use the analogy of the criminal courts, right? We have a high crime rate in this country. We have the minimum sentencing dispensation, which clearly sets out minimum sentences to be imposed when certain crimes are committed. But it contains a provision that under under substantial and compelling circumstances, the sentencing court may deviate. So where it deviates, it exercises a discretion similar, it's a wide discretion, akin to the one this court exercises in terms of section 1721B of the Constitution. So are you saying because in different cases, courts, given the facts in that case, have exercised their discretion differently, then there are conflicting judgments? That cannot be.
I'm saying that on a matter of principle, not on how the discretion is exercised, because the Supreme Court of Appeal could not have given the judgment it gave if the no profit principle is immutable.
Nobody's saying it's immutable.
If it's not,
saying, I mean, I've looked at how you deal with this point in your heads of argument.
Yes.
In fact, the way you approach it is entirely incorrect. There is no law that says a tenderer who is awarded a tender irregularly can never profit, which is what you state in your heads of argument. There's no law that says that. Of course, it's a value judgment. Under certain circumstances, tenderers are allowed to profit.
Yes, my lady.
Now, the question is, Do those circumstances exist here?
I'm saying
And I've pointed out to you that the constitutional court's approach is to ensure that a party is compensated and that a party is not unduly prejudiced. The present order fully caters for that.
No, my lady, let me deal with that, because it's not correct. My client is a professional man, so he renders professional services. If he's constrained to his expense, he is in no way, manner, or form compensated for what he did.
His professional fees are an expense.
No, it's not. That's the point.
How are his professional fees not an expense?
Because his expenses, his office and his petrol and his whatever, the work that he did as a professional. Your order says,
Mr. Tron, when you file your tax return at SARS,
yes.
Your professional fees, are they not an expense?
No, they're income. It's income. I mean, that's the point. His expenses, what he expends, his telephone, petrol, and his secretary and whatever, and his fees is income. This order says that there must be an income and expense exercise done, and then I can only get the expense. It's it would disentitle any professional person completely of his remuneration. So no, my lady, the order is currently couched. My client is completely not recompensed under this order for what he did, his intellectual property, the work that he did as a professional. So no, I don't agree with your ladyship.
I also don't agree. I don't agree with how you are approaching his compensation. That issue is not before me. That issue as to whether his professional fees are an expense or they are not an expense, that issue is not before me. What the order says is that he must be compensated for his expenses.
It says in 6, income and expenditure. And after setting off the prepaid amounts, the reasonable expenses.
Mr. Tron, in an accounting sense, professional fees are an expense.
No, my lady, it's the income of a professional person. He also has expenses, but those expenses are telephones and secretary and the like. He gets compensated for the application of his intellectual.
Remember my background. I was an attorney,
yes,
not an advocate. The two professions function very differently. So, as an attorney, from what you charge a client, you would still draw a salary. You wouldn't keep what is left after you've paid disbursements as an income. So, but that issue is really not before me, Mr. Troy.
But the submission is that your ladyship's order is not just and equitable, because that's the effect of the order, is that my client's not recompensed. My lady, having not considered the evidence that was before you, there's a total failure of the exercise of your discretion, because there's no facts underlying it. It is by its nature capricious, because you didn't have regard to the underlying evidence. It is also therefore not for substantive reasons, because you didn't look at the evidence that was before you. Your exercise of the discretion is therefore can therefore on appeal be set aside. And I say that on the same facts, the Supreme Court of Appeal found differently, that panel would have found differently had they had these facts before them. And I therefore say that your ladyship should grant leave, as another court would come to a different conclusion. The fact whether my client would or would not have been awarded the tender is not a fact, it's speculation. And one can also not exercise a discretion on a speculative basis. If the state wanted to put other evidence before you that other tenderers were in fact disadvantaged, then they should have done so. There's no such evidence before you, and it's a speculation. Your ladyship is was constrained to make a finding on the facts before you and the evidence before you, and not a speculative possibility, which Mr. Skeper says doesn't even rise to the level of a probability. It doesn't rise to the level of a probability. What your ladyship does have before you, or did have before you, but did not have regard to, is the minutes, the site meeting minutes, which shows that there were 2 other tenderers present at the site meeting. So it's pure speculation to say that somebody else would or could have done the work and would have got the tender.
No, Mr. Skeppers, that issue is not fully ventilated before me. Even your client does not explain how he got to be chosen over and above the other tenderers. What we know is that the processes were not followed.
Yes, my lady, I agree, but I echo Mr. Skeppers' argument where he says a tenderer is blind to that part of the process. The tenderer doesn't know whether the state complied with its own tender processes. Mr. Skeppers sounded another warning to your ladyship, which I echo. I've been asked to advise how to make clients bulletproof against this happening to them again, because the contracting with the state, you don't know whether they complied. Even if there was a guarantee in a contract with the state, where the state's representative guarantees that that the tender processes were followed, if they were not in fact followed and they come to court, the court must set it aside because it's unconstitutional, and the tenderer is back in the same position. These type of judgments, where profit is taken away from somebody that performed, will lead to a situation where the companies will not contract with the state because it's too dangerous. It is a iniquitous
speculative
position. It's not speculative, my lady. I'm making this submission because I already have clients that says, well, then we're not going to invest because it's too dangerous.
Well, that evidence is not before me, Mr.
No, it's a submission, my lady. It's a submission. It's a submission.
The state is the biggest buyer of services and products, and the state is never desperate for suppliers. There are many people actually who want to do business with the state.
But it will eventually attract a premium for risk, my lady. It's a dangerous precedent. It's an extremely dangerous precedent, because they will build in a premium for risk, and that will make every service for the state more expensive. This issue is of national importance. That's why I'm saying that under that section, this must be cleared up, and preferably by the Constitutional Court, and preferably soon. It's got dire implications for contracting with the state, and for professional people that contract with the state, so much the more. If Mr. Skeppers made the submissions by referring to our position. If I'm contracted by the state attorney and there's something wrong, I would become disentitled to my professional fee, and I'll have to ascribe a little bit of telephone and a little bit of rent for the time that I spent. And that's what I will be entitled to. That's the effect it has on my client, who's the engineer. It's all those cases deal with the contractor, where there's nuts and bolts that they bought and that they have to be recompensed for. But only the expenses line, but it's like Mr. Skeper says, it's damages in a company that small percentage that can't be made up because you can't get the time back. My lady, with the greatest of respect, the failure to take the evidence into account makes the exercise of the discretion. There wasn't actually a discretion exercised in those circumstances, and I say that the Supreme Court of Appeal on these facts, that same panel that sat in Fetagomo, would have come to a different conclusion. My lady, as far as the question as to which court is concerned, The SIU Act is a specific act that deals specifically with the tribunal, where the Superior Courts Act is a general act that deals with all courts. The SIU Act is therefore applies, and my submission would be that you have no choice but to send us to the full bench, even though I would love to short circuit this for the reasons that I've set out. I don't think I can make the submission that you can do that. But I will address it also in my further heads to you. Those are my submissions. Those are my submissions.
Thank you, Mr. Semenya.
Thank you, my lady. Can we perhaps go back to Caledon 1? Your ladyship would recall that there was no answering affidavit filed to that application. Instead, what we were arguing there was whether or not you're a court or not a court. You came with a judgment that told us that you are a court, and then we got to the postponement process. When we got there, we ended up by agreement between the parties saying there is an infraction of the Constitution under 217. Now we have to unbundle what that concession, what that admission, concession, and order means. It means that there has been an infraction on the basis of the allegations that were made in that application. That is just a process issue. Now, upon reflection, my lady, I need to come and make this submission again, which is different from what is in the written submissions. But I want to illustrate it. My lady, there are two ways in which you have maybe a little bit more, but for purposes of my argument now, you either have viva voce evidence tendered. In this instance, there was no viva voce evidence tendered at all. Or you either then have a documentary evidence which is submitted as an exhibit. And I'm trying to say, my lady, it may very well be that you are gracious in admitting your error. But I have to be fair to myself and my clients that if the matter goes on appeal, that the finding that there was no evidence on the matter is correct. What concessions I may make as a counsel for the other side or not, it's also not evidence. Your ladyship ought to have landed with Exhibit A and Exhibit B in respect of the experts, witnesses. That would constitute it as evidence. Not that we agreed and nobody agreed, but that's relevant.
Mr. Semenya.
Yes.
On the evidence issue, remember when I exercise a discretion in terms of section 1721B and make a value judgment, right? So on the evidence that was filed by way of affidavit, the evidence of the factual witnesses, don't you think that that evidence, particularly that evidence, was relevant for the exercise of my discretion?
My lady, I'm addressing now a procedural issue before the legal issue of law. I'll come there.
Yes.
All I'm trying to say to your ladyship now, so that I don't get it wrong elsewhere. The procedure for filing of witness statements does not mean those witness statements are evidence. They are filed under oath. But
Mr. Tron, I'm going to ask that you switch off your video. Please switch off your video. Thank you.
My lady, as a matter of practice,
Yes.
you file an affidavit, but it is not evidence. You have to call that witness to say, do you confirm under oath in this court as evidence what you are saying in your affidavit? Otherwise, who cross-examines an affidavit?
Did you not concede that evidence?
My lady?
Did you not concede that evidence as filed?
No, my lady. If I have considered it, what a practitioner does is to say to your ladyship, my lady, may Exhibit A be admitted into the evidence. This is.
Okay, I think it's important that I have the transcription.
Okay.
I think it's important that I have a transcription.
Okay. I just didn't want to be silent on the point again.
No, I'm glad you are raising it, Mr. Semenya, because I mean I'm questioned on how I approach this matter, and I've been grappling with it.
Okay.
Because these statements were filed. Now I need to have regard to the submissions that were made. And you know, that is why I didn't want to go there, because we don't have the transcription in front of us. And I'm sitting in a position of authority. I don't want to be imposing my view of what the submissions were on the parties. But I think it's important that we have that transcription for the purpose of finally, having this application fully ventilated and determined. I think it's important.
I can't disagree, my lady. I accept that proposition. It would be insightful to see whether when we have the transcription, whether there was an exhibit A and B to be admitted into evidence.
No, for me, it's for a different point as to what the parties' oral submissions were regarding that evidence.
Okay.
Yes.
All right.
Because the applicants are saying you considered it, was not disputed, that evidence was accepted. And you are saying, no, they should have led evidence.
No. I'm not saying they should have led Viva Voce evidence. I'm saying they should have said, your ladyship, may this evidence be admitted as exhibit A or B?
No, well,
okay.
I think the question is whether you submitted that you will proceed on the basis of the evidence of the applicant's witnesses.
Yes, not on the statements of applicants' witnesses.
No, Mr.
in any case, we'll get there.
And that becomes a very technical point. It
is very technical.
The witness statements are on affidavit. It is evidence.
Okay, my lady, we will jump that if we get to the appeal. I just raised it so that we.
Because the minutes of the pre-trial are very clear that you actually agreed in that forum that you will proceed on the basis of the defendant's evidence, which was filed and I did not take into account.
Okay, my lady, let me proceed to the next submission. My lady, let us look at then what happens in Caledon 2.
Yes.
And I'm saying a just and equitable order. We make 2 points about it. The first is that question it's a question of law. It's not a question of experts. So no expert evidence was going to shed any light to your ladyship about what is just and equitable. And we made that point even early to say, we're not perturbed, now that we are in 172.1b, we're not perturbed about all those things because the inherent admission about that contract being inconsistent with the Constitution has already been admitted by the other side. So to say a reliance on those experts was going to help your ladyship to find what is just and equitable can be correct. Those witnesses were not going to be able to help you get to that determination as experts. Now,
but were they not gonna advance factors to be considered? Obviously, they don't decide what's just and equitable. I decide, right?
Right.
But it's on the basis of evidence that they adduce that I make that decision.
That's why I started, my lady, by saying, let's look at where Caledon 1 was. There were allegations, there were affidavits filed, there were everything else. And then we got to where we are. So your ladyship would have known the allegations that were made in Caledon 1 by the SIU about defective performance that were never answered. So to say there is uncontested evidence is untrue. As a matter of process, when the notice of motion was filed, it was filed with affidavits complaining about a whole plethora of irregularities, which the applicants now came to concede when they admitted that there was irregularities under 170 of 217, which was the contract was an affront to the 217 provision of the Constitution. So it's not like it was not contested. Otherwise, if the allegations made in the founding affidavit were contested, they would not have conceded that there was a breach of 217. Now let me address a different point. This thing about them being innocent. In the SABC matter by Kitley J, we deal with that in paragraph 28, where we cite the judgment in the relevant part. It is a case of willful blindness and deserves no exculpation. So they're saying it's an emergency and this and the other. Everybody in this country, including business, must know there's a section 217 if they want to do business with the state. They can't say we don't know how the state procures services. They must know. But if they are in willful blindness, they deserve no exculpation. To accept this as an excuse would encourage contracting parties to avoid asking the hard questions necessary to achieve the objectives of 217 of the Constitution. This would not be in the public interest, says the judgment.
Mr. Semenya, paragraph?
28 of the written submissions.
Which SABC judgment?
It's a SABC SOC Limited and another versus Mott McDonald's.
Oh, it's Mott McDonald's. Okay.
Yes.
There's a number of SABC matters on the same issue, so SABC is really keeping the courts busy on irregularities.
Yes, no, I'm sorry about that, my lady. It is paragraph 28, and the citation is there as well as a footnote, but it is the Mott McDonald one. So there is no appreciation about the concession made about that contract being inconsistent with the Constitution. Now, let me address the third element about this application. My lady, that 172(1)(b, it's an exercise of a discretion, admits of no debate. That's what it is. Now, your ladyship recognizes that there is a broad spectrum on how that relief or remedy is awarded. The no profit principle which the judgment records is good law. Nobody says it is bad law that your ladyship took a direction that says no profit is realizable under these circumstances. So you can't be criticized for applying what the Constitutional Court says is good law. It is something different if in the exercise of that discretion you come to a conclusion that no court has ever recognized to be a cognizable basis of judgment. So they're saying what your ladyship is saying here, no profit, is bad law. It can be. They must show us something else. Now, what I seem to hear them say is that your exercise of the discretion by excluding the factual material that was before your ladyship makes that discretion exercisable wrong. But that can be. If the outcome of a badly exercised discretion is the same as the good law of the highest court, then you're making no point. Those other submissions we have, my lady, we will obviously amplify our submissions in relation to the question of application for leave to appeal.
Yes, Mpo has just sent me the correspondence. It was addressed on the 22nd of March to Marcia van Vieren, Joyce Neyman, Stella Zondi. I believe all those are your attorneys. And it says the issue you raised in your letter is a legal issue yet to be determined by the tribunal. Then she attached the directives in Lithuania, which Mr. Tron referred to. Regrettably, Ms. Lithuania did not persist with the application for leave to appeal. Hence, the issue is yet to be determined that I've put to you. Then she included the directive. She, meaning I, direct that in the event that you are of the view that the obiter statement in Caledon River is wrong, and that the tribunal is empowered to consider the application for leave to appeal, you should file the application with the tribunal for a proper determination of the issue. So this was the invitation for the issue to be argued.
I concede that, my lady.
Thank you. Mr. Are you?
I'm done.
I'm
done.
Mr. Skippers.
May it please you, my lady.
May
I'm
I
going to be
ask
very brief.
counsel who are not arguing to switch off their videos, please? Thank you. Thank you.
Thank you, my lady. My lady, I'm going to be very brief because we have thoroughly trampled all the issues where we clearly disagree on some issues, and we rely on your ladyship's wisdom in order to cut the baby in two and decide where it goes, whether it stays or whether it goes to the full bench or the SCA.
Remember, the mother of the baby will never want the baby killed, right?
May it please the court, they will shout and cry, my lady, as we do to go to the SCA. My lady, if we look at what Mr. Semenya said, and with the greatest of respect towards him, that was not what happened in court. The evidence was not disputed. He accepted the factual basis of both the experts and the factual witnesses on what transpired. We also need to consider what was said in the order when the compromise was reached and the draft order prepared for your ladyship, which your ladyship then issued judgment or an order on, declaring the contract constitutionally invalid and ordering the separation. It clearly provided for a limited basis upon which the compromise was reached. To now argue that those facts are uncontested before your ladyship with respect fails to honor the agreement that was reached and the draft order that was prepared. The draft order was very specific and included no evidence whatsoever of malfeasance, and specifically referred to the failure to incorporate the provisions of the Treasury, to comply with the provisions of the Treasury regulations. So those are the two issues that Mr. Semenya referred to, Ladyship. On that order is at case lines 01922. Your Ladyship will find that order there, and that was the order that was made by consent. My lady, we can argue all we want on what the different interpretations are, and Mr. Tron set out the basis that your Ladyship did not consider the evidence that was uncontested before you, and I submit that on its own has an impact on the discretion to be exercised, and at least upon consideration of that evidence, and that is what we argued, I submit that another court would come to a different finding. I will, however, address the issue of the conundrum, should we need leave to appeal, whether your Ladyship can then give it to the SCA, or whether your Ladyship is bound by the provisions of the SIU Act to only grant leave to the full bench in our supplementary heads of argument. Will your Ladyship just indicate to us when your Ladyship would want the heads of argument filed, so that we at least have a timeline to get this matter to finality and your Ladyship can proceed to judgment?
How long do you need? A week?
I think a week is fair, my lady. I think next week Friday would be fine from our side.
Mr. Semenya, you're not coming back, so you can just address me on whether a week is sufficient.
Yes, my lady. Would it be more practical that we have sight of what they write, so that we can respond maybe 2 days after?
That's fine. So if they file by Friday, when would you like to file by? Friday will be the 27th.
The next Friday is the 3rd of June, my lady.
Would that do, my lady?
3rd June, that's fine. Thank you.
My lady, that's the only issues in the reply to Mr. Semenya's address that I have. Thank you, my lady.
Thank you.
Yes, my lady, I agree with Mr. Skepper's submissions, both on what the agreement was when the concession was made and you made your order. Nothing remained of what went before. It was a compromise between the parties, and Mr. Semenya can't now rely on that first application, which was opposed and wasn't adjudicated. So really, and the other thing is the agreement in the minutes is clear. On the day that we appeared in front of your Ladyship, Mr. Skeepers tendered his expert as viva voce, and you told him that you didn't need to do that. So to now contend that evidence wasn't before you is simply wrong.
I do not recall that part, Mr.
Well, you will get the transcription. I remember it clearly. But even if that wasn't said, 3.5 of that minute is very clear.
Yeah, but what I remember is Mr. Skipper saying to me that the quantum is not ready, is not fully ventilated. That's what I remember.
That I don't remember that, but it may very well be so. I wasn't, that wasn't foremost in my mind on the day. My lady, I made the one central submission which I wish to repeat, that in not taking into account the evidentiary material before you, there was no exercise of a discretion. It's capricious, and it's not on grounds. Having done that, the question is, will another court interfere? And the answer, I say, is that the Supreme Court of Appeal would on these facts give a similar judgment to Feta Khomo, and that another court would come to a different conclusion. As your Ladyship, please.
Thank you. Okay, we've come to the end of today's hearing.
My lady,
yes.
Might I just ask, for the purposes of the further submission, would we be having the transcription already?
Okay, we need to decide on the transcription. The transcription is not required for the further submission,
Okay.
for the further submissions,
Okay.
right?
All right.
If your ladyship requires it for a determination of this application, then your
I
ladyship
do
must
require
say
it
so.
for determination. Yeah,
Yes. Well, then
a determination.
our attorneys will contact your registrar, and then we'll see. We'll try and facilitate it.
The question is whether that impairs the arranged dates or not.
I don't see why, because it's about whether
It's on a different point. I need it for a different issue.
Okay.
So that shouldn't delay you.
Thank you, my lady.
Thank you, my lady.
Thank you very much. I'm indebted to you for your assistance, your professionalism, and your politeness.
As you please, my lady.
Thank you.
Thank you,
my lady.